This courtroom scene turns intense fast when a man charged with driving without a license tries to put the entire legal system on trial instead of himself. From the very start, he refuses to answer the charge directly and begins questioning the court's authority, claiming he doesn't understand the nature and cause of the case. He throws out familiar sovereign citizen-style arguments, asking whether he's under common law or admiralty law, and suggesting the court may not even have jurisdiction over him. The judge, calm but clearly experienced with this kind of situation, doesn't lose control for a second. Patiently, she explains what each plea means: guilty, not guilty, and no contest, and makes it clear that the court is moving forward whether the defendant agrees with the process or not. But the defendant keeps circling back to his paperwork, insisting a special appearance document he filed should protect him from the court's authority. The judge quickly shuts that down, pointing out the document isn't even a proper legal filing and doesn't dismiss anything. When he refuses to enter a plea, still claiming he doesn't understand the jurisdiction, the judge steps in and enters a not guilty plea on his behalf, a move that keeps the case alive and pushes it toward trial. Things escalate again when he demands a jury trial, only to learn that even that requires following actual legal procedure and filing the right motion. It's a textbook courtroom clash, internet legal theories versus real-world law, and the judge makes it clear which one actually counts.
I'm going to ask how you wish to proceed in regards to a plea. Right now, do you have a plan in regards to an attorney? Are you hiring an attorney, asking the court to appoint, representing yourself?
Represent myself, Your Honor.
Very well. Mr. Curvin, you looks like you're 33 years old. So absent some other compelling reason, you'd be able to represent yourself. If you wish to, I'm going to ask what your plea is. If you wish to have a trial, if you wish to, I don't know if you qualify for a diversion, if you wish to try to get the case resolved either through counsel or yourself with the county attorney's office, any of those things, then your plea should be not guilty. If you choose to plead guilty, then we would proceed to sentencing. I would hear from both parties and a pronounced sentence. If you plead no contest, that is then if the state were to present what we refer to as a proffer, a person who's pleading no contest are not challenging the charge, but they're not pleading guilty per se. If there's a proffer that supports the facts that would result in a guilty verdict, then that person would be found guilty and we'd proceed to sentencing in the same manner as I described before. With those things in mind, how do you wish to plead? Guilty, not guilty, or no contest?
Are we on the record?
Yes.
Well, on the record before I make a plea, I'd like to simply state that I do not understand the nature and cause of action in regard of the elements of my personal jurisdiction, the venue, and the nature cause of action until the prosecution has allegedly alleged them for me, and therefore I'm not able to enter a plea until then. I'd like to know if it's going to be if I'm going to be tried under common law, or is it going to be under merit?
Can you speak up a little bit? It's difficult to hear you.
I got my headphones on. Did you hear what I said, or just what part did you need to
I heard part of what you said. So,
okay. I was saying, for the record, I did not simply understand nature and cause of action brought against me, with regards of the elements of our personal jurisdiction, and also the nature cause of action until the jurisdiction, the prosecution has let me know what they're going to try me underneath, so I can let you know what I'm going to make my plea. I'm not really sure if it's under common law or is it maritime amity law. So I can know how to defend myself, and then I can enter my plea.
All right. Have you filed a motion for discovery in this case?
I filed in I put a special appearance and affidavit in about a week ago.
Well, there's something that's listed as correspondence in the court file. I'm looking at it now. It's not an official pleading. Neither does it state that you've requested information from the state that we refer to as discovery.
You didn't receive. I emailed. I actually faxed the. I faxed the special appearance. Did you receive it?
There's a document that looks like it is served or before a notary in Oklahoma that reflects what appears to be your signature and says respondent beneficiary of the named defendant in constitutional rights / benefits.
It should
Is
be
that
like
the document you're referring to?
Yeah, I think is it just only one they went through? Because there's like 4 pages, 4 or 5, a few pages that went through, not just one.
There's a one-page document.
There's only one. It's supposed to be more. I faxed to more over there. It was supposed to be like 4 pages.
It's one page. Where it begins is at the top. It says the Supreme Court said in U.S. versus Mirsky.
Yeah, I have a copy right here with me. I think you're just referring to the last page. And I sent like 4 pages of them. I think I got it notarized at the end of it, and I think the notary already sent the last page to you, but it was supposed to be 4 more pages to go with that. And that was the special appearance.
All right. Are you entering a plea of guilty, not guilty, or no contest?
Can I enter a plea at the moment because I'm not sure what I'm going to be tried under. What jurisdiction am I going to be tried under? I do not understand the nature of the cause of action being brought up yesterday.
Well, I've explained what you're charged with.
Yes.
I'm going to put you down as a plea of not guilty and set this matter for trial. If you wish to,
because I was my special appearance didn't make it out. Like I need to reset. How can I reset it so I can have a chance to resend my special appearance because it didn't make it in. I guess you only had the last copy of it. There's 4 more pages that you didn't receive. I need to enter that in beforehand. How can I reset until I can do that? I have time to do that. I can do it today, and we can reset it for this same time next week if that's okay with you.
I'm going to go ahead and set this for trial. You can, if you have pretrial motions that you'd like to address, they need to be properly filed.
Okay.
Sometimes if people are representing themselves, they're still held to the same standard as an attorney would be.
Yes, sir.
And sometimes people don't have the experience to do that correctly. So there's an advantage to having an attorney. But I'm going to set aside 2 hours for bench trial.
I'd like to be tried by jury if that's okay. If I'm going to be separate trial, if it has to be separate trial.
Have you made a written request for trial by jury?
I have not. This is my first appearance today.
If you're seeking to have a jury trial, then you're going to need to file a written motion in that regard.
Okay.
Again, pursuant to Kansas law, there are restrictions in that regard. When we set a jury trial, I generally have a pretrial date that we have. You will be required to be here at Elk County to conduct that hearing. If you have pretrial motions that you're wishing to have heard, we typically would do that in advance at a pretrial. I'm going to set a pretrial date at this time. That'll give you an opportunity to place your written motion for request for jury trial.
The courtroom is quiet at first, a typical scene for a routine traffic case. But the moment the defendant stands up, it becomes clear this is not going to be a normal hearing. The man charged with driving without a license immediately begins challenging the authority of the court itself. His words are precise, almost rehearsed, and he questions whether the judge even has the right to hear his case. He claims he does not understand the nature of the action against him, and he wants to know whether he is being tried under common law or something else entirely. From the very first moment, he sets the tone. He is not here to follow the ordinary rules, and he believes that his personal interpretation of law should take precedence over the established system. The judge listens patiently, her demeanor calm, showing no hint of frustration or surprise. She doesn't respond to the provocations in the way many would expect. She doesn't argue or interrupt. Instead, she speaks slowly and clearly, explaining what a plea means, how the process works, and what the defendant is facing. She outlines the basic options of pleading guilty, not guilty, or no contest, emphasizing the consequences of each choice. She explains that a not guilty plea is not just a refusal to admit guilt, but a way to give the legal process time to work, to allow for evidence to be reviewed, and for both sides to prepare. It's a subtle reminder that the courtroom moves forward based on procedure, not on whether a defendant believes the system should recognize them. The defendant is undeterred. He produces what he calls a special appearance document, an affidavit that he believes exempts him from the authority of the court. He insists that because he filed this paper, the judge cannot proceed against him. The judge examines the document and points out the obvious. It is incomplete, it does not meet the legal requirements, and it does not dismiss the case. Despite his insistence, the court will not be delayed or dismissed by a piece of paper that has no legal effect. The room remains tense, but the judge maintains control, calmly explaining why his document cannot change the course of the proceedings. The process is not about personal belief, it is about the law as it is written and applied. When asked to enter a plea, the defendant refuses. He claims he cannot, because he does not understand the court's jurisdiction over him. He repeats the same arguments he has prepared, hoping that the court will be swayed by his refusal. But the judge is not swayed. She enters a not guilty plea on his behalf, a move that is entirely within her authority. This ensures that the case will continue toward trial, despite the defendant's attempts to pause or redirect it. The message is clear. The courtroom does not revolve around individual belief, no matter how fervently expressed. The process is steady, and it cannot be stopped by arguments that have no legal standing. The defendant's next move is to demand a jury trial, as if simply asking for it is enough to make it happen. The judge responds with the same calm authority, explaining that there is a proper procedure to request a jury. He must submit a written motion and follow the law. This is another demonstration that the court runs on rules and structure. Personal belief does not grant automatic exceptions. The hearing continues, with the judge patiently outlining what must be done for motions, pre-trial schedules, and eventual trial dates. The defendant listens, occasionally objecting or repeating his previous arguments, but the court's momentum is unbroken. What makes this hearing remarkable is the contrast between the defendant's approach and the court's response. On one side, there is an individual armed with ideas, documents, and arguments he believes give him control. On the other side, there is a system designed to operate independently of personal opinion, moving forward with predictability and authority. The tension is palpable, but there is no chaos. The courtroom is orderly, and the judge's guidance ensures that each step is followed, that nothing is skipped, and that the law is applied consistently. Even as the defendant returns to familiar arguments about jurisdiction and special documents, the judge's voice remains calm, explaining the legal realities with clarity. The process is almost surgical in its precision. The defendant's refusal to acknowledge authority, his insistence on filing incomplete paperwork, and his repeated questions about the court's power all serve to highlight how the legal system handles challenges that are based more on belief than on law. The judge does not debate, does not react emotionally, and does not allow frustration to interrupt the proceedings. Instead, she uses procedure as a tool, guiding the defendant, the courtroom, and anyone observing through exactly what the law requires and why it matters. As the hearing progresses, the stakes remain clear. The defendant is still facing a charge, and his refusal to enter a plea or follow procedure does not eliminate that fact. The judge's not guilty plea entry ensures the case moves forward, while the explanation of jury procedures and pre-trial motions reminds everyone that rules govern the process, not arguments. Every attempt to manipulate, delay, or redefine the law is met with the same unwavering adherence to procedure. By the end of the session, the courtroom has demonstrated something profound. The system is resilient, designed to function despite attempts to bend or bypass it. The law moves forward, the charges remain in place, and the process continues. Even though the hearing is challenging, it also serves as an example. The defendant's actions, his documents, and his arguments are all part of a strategy he believes will give him an advantage. Yet, the court's approach is simple and effective. There is no rush, no panic, no overreaction. The judge's focus remains on the application of rules, the explanation of options, and the orderly advancement of the case. This careful balance between authority and patience keeps the hearing moving, demonstrates the limits of personal belief against established procedure, and underscores why courtroom structure exists in the first place. The encounter leaves a lasting impression. When someone challenges the system with arguments, paperwork, and refusal to comply, the court responds with consistency, not confrontation. Personal strategies may be elaborate, but the law follows its own path, and those who attempt to redirect it quickly discover that the process is larger than any one individual.